Assalamu alaikum and welcome back to Just Law on IQRA TV. Just before the break, we had a caller who was inquiring about the position in terms of applying for a visa, or she'd applied for a visa, she'd overstayed for about 10 years, had legally married and had applied for a visa to try and regularize her stay in the UK. Now that fits in quite well with the topic that we're dealing with today, which is the position of overstayers. How can they regularize their stay in the United Kingdom? And just before the break, I was looking at the position of those who are single and had overstayed, and explained that the current position is that they must have lived in the UK for 20 years. What I want to move on to is the situation where they are not single anymore, they have a partner or they are married. Now, does that change things? Is it easier for somebody in that situation where they have a partner, Islamically married or married under English law? Does that change their situation? Does it make it easier for them to obtain a visa in the United Kingdom? Now, what you look at is initially the status of the person that they're married to. If they're married to someone who is a British citizen, then potentially it does make it easier for them to get some kind of legal residence in the United Kingdom. However, marriage to a British citizen, an overstayer getting married to a British citizen in itself isn't enough. What is really required before the Home Office is likely to grant some kind of legal residence is that from the relationship there should be there is a child from the relationship. Now, if there is a child, so if somebody is married to or in a relationship with somebody who is British, once they have a child, it normally follows that the child is also British. In that situation, it is very likely that if an application is made to regularize one's stay in the United Kingdom based on the relationship with the partner and based on there being a parental relationship with the child who's British, then the likelihood is if an application is made, the Home Office will grant the person who's overstayed a visa to remain in the United Kingdom. And that is possible from within the United Kingdom without having to leave the country. But the key thing is really that from the relationship, from the marriage, there has to be a child who obviously, if the relationship is with somebody who is British, it would follow that the child is British. Now that is really the crux of the matter in relation to the call we had just before the break, and during the break I was having a more detailed conversation with the lady. But this is the key thing, that the marriage or the relationship is in itself not necessarily enough. We'll look at this in greater detail after we've taken our next call. Hello, assalamu alaikum.
Assalamu alaikum.
Ji walaikum salam. Ji bhai.
I would like to put one question
to
the lawyer.
Yep, sure. You're live on air, so fire away.
I don't want to go on live, but can you put this question to him, please?
You are live on air.
Am I?
Yeah. So it's up to you whether you want to put the question live on air or you want to leave a message with the control room. It's up to you what you want to do.
Okay, I'll go on the live then.
Okay. Yep. Carry on. Fire away. Yep.
Yeah, I'll wait. Thank you.
Okay. All right. Okay. Sorry, you're live on air. So do you want to put the question?
Hello,
then?
assalamu alaikum.
Walaikum salam. Ji, what's your question? You're live on air.
Yeah, basically I would like to.
You know, there's a TV, your TV's on at the back.
Oh, I see. Yeah,
so
okay.
what you're getting is there's an echo.
Okay.
If you turn the volume down a bit.
Yes, I did. Yeah,
okay.
I did.
Okay, brother. Go on. Sorry, fire away, please.
Thank you very much.
Okay. Yep.
So can you hear me?
Yeah, I can hear you loud and clear. Yep.
Okay, I would like to put one question, basically generally maybe help everyone.
Yep.
Those who came to this country as under a spouse visa,
right, okay.
and they are attending a college for ESOL,
yep.
Which is Life for Skilled.
Yep, okay.
And there is a fund which is called Bursary Fund.
Yep, okay.
And that is under the household income, which is under 20,000 something.
Okay.
They are qualified for the free tuition
Yep. Okay.
fees.
Yep.
And will this affect their immigration status? Because no request to public fund. So I want to know whether it is a public fund or generally. Yes or no?
It's not a public fund, no. Because, when they say no recourse to public funds is actually defined. So public funds isn't general, as in whatever the government gives you in terms of assistance. That's not what public funds amounts to as far as immigration law is concerned. Public funds are actually defined benefits. So if you bring up the rules which govern what are public funds, it tells you there's about 10-15 things which amount to public funds, such as universal credit, working tax credit, child benefits, etc. So if it doesn't fall into that list, it's not regarded as a public fund as far as immigration is concerned. Now, student grants, etc., they won't necessarily fall into the definition of public funds. So it won't be a public fund as far as immigration rules are concerned. However, there's a separate matter, which is that the university or the college, when they look at the applicant's immigration status, they may themselves say that we are not prepared to extend, we are not prepared to give these benefits to somebody who has immigration status which is not settled status. So they might have their own rules, which means that you don't qualify for whatever the student grant is, student bursary is. But that is to do with the college or the university's own rules. It's got nothing to do with the definition of public funds within the immigration rules. So in answer to your questions, they're not public funds. As far as immigration is concerned, it doesn't affect your status at all if you obtain those benefits. However, when you apply for those benefits, the university itself might say, well, no, you don't qualify for that because of X, Y, and Z. But that's a separate matter. That's the university or the college's own internal requirements or conditions for qualifying for those benefits.
So, sir, might not affect for the immigration status.
No.
Oh, thank you very much.
Definitely not. Yep.
Oh, thank you very much indeed.
Thank you very much for your call.
It's a great help. Your program is so nice that you explain it very nicely.
No problem at all.
And we are grateful. Thank you very much.
Thank you for those kind words. Thank you. Bye. We'll take our next call. Hello, Assalamu alaikum.
Wa alaikum salam. Am I on live?
You are, brother. You're live on air. Yeah.
Okay, thank you. This question is relating to the application for the British citizenship as a naturalized citizen.
Yep.
I'm trying to find out, I've got the ILR based on the 5-year route from the spouse's marriage.
Okay.
So after how long I can apply for the citizenship?
Okay.
Is there any time difference or is there any number of months that I need to be in the UK?
So what you look at when you do that is your spouse British or does she just have indefinite? If she's British, then you can apply straight away after, because there are two rules. One is you need 5 years residence, which you would have if you're here as a spouse under the 5-year route. So once you get indefinite leave, you've obviously spent 5 years in the UK. If your wife is British, you can apply straight away after that. You don't have to wait. If your wife isn't British, let's say she just has indefinite leave to remain, she isn't British, then you have to wait 1 more year. So in your situation, your wife is British, so you can apply for British citizenship straight away. You don't have to wait. There are obviously other requirements which need to be fulfilled in terms of absences from the UK, in terms of good character, etc. Assuming there's no problems there, in terms of time-wise, because you've completed 5 years and your wife is British, you can apply straight away for British nationality. Okay. Does that answer your question, brother? Yep.
Thank you so much.
Okay, brilliant. Thank you very much. Jazakallah. Thank you for calling. Thank you. Right. So we were looking at, just before the calls, at the position of those who have overstayed. And what I was saying is that the position for those who have overstayed, and if they are in a relationship, they have a partner, they have a wife, etc., their position is much better if they want to apply for some kind of stay in the UK. They've overstayed, but they do have a partner. Their position is much better. But I should clarify that the reality is, and this fits in with the call that we had just before the break that we took, is that where the relationship is with somebody who is British, the reality is unless there are children from the relationship, there are children that the partner has from a previous relationship with whom you have parental responsibility now. Without that, it is very, very difficult to obtain some kind of legal residence in the UK. There are exceptions, I accept that. There may be exceptional circumstances where, despite there being no children, some kind of visa should be granted. But in reality, in the vast majority of cases, let's say in the 95%, 99% of cases that we deal with, unless there are children, even though there is a British partner with whom there is a real, genuine relationship, and the person who's overstayed has been living with their partner for a number of years, they won't grant some kind of leave unless there are children. Let's take our next call. Hello, assalamu alaikum.
Assalamu alaikum.
Ji, brother, what's your question?
I just want to ask whether this you can do citizenship for somebody.
Yeah, sorry. When can you apply for citizenship? Is that what your question is?
Huh?
Oh, sorry.
Yeah, I want to apply. I don't know how much it took. I've got my indefinite leave since 2003 anyway.
Okay. So you've had your indefinite leave since
2003.
Okay, all right. And you want to look at whether you should apply for indefinite leave for British nationality?
Yeah, I don't know how much it will cost.
Right. In terms of fees, the fees are in the region of £1,300 when you apply for British nationality. It's about £1,300 when you apply for British nationality. Now, because you've got residence, which is more than 5 years, and you had your indefinite leave for a long time.
I've got my indefinite since 2003.
It would have been cheaper had you applied then. It would have cost you possibly £100, £200 had you made the application then. But it is now. It has gone up to £1,300, and every year.
I need to apply by myself.
Sorry, say again. I do apologize. You're breaking up. So
can I apply?
Yes, definitely. You can apply, and the application is reasonably straightforward. If you go onto the Home Office website, you should be able to download their form. Form AN has some guidance to it as well, separate guidance to it as well. It's reasonably straightforward. You've got the length of residence. You need to look at your absences. If your absences aren't more than, say, 90 days in the last year, and then 450 days in the last 5 years, potentially, and there's no issues in terms of good character, potentially you can apply. There is one additional requirement which probably didn't apply back in 2003.
I'm retired since 2013 anyway.
Right, okay. So there is an English requirement, but it doesn't apply to anybody who's 65 or over.
Because so they say we should go to solicitor or this or that.
It's not that complicated. To be quite honest, it's something that you could do yourself. If you go onto the government website, if you download the form, if you look at the guidance, it's potentially something that you could do yourself. But obviously, if you're not sure, don't take a risk. Get some advice from a lawyer, Citizens Advice Bureau, wherever it is. Okay, brilliant. Thank you very much for your call. Thank you. So, just before the call, I was explaining that the position of somebody who has overstayed in the UK is in a relationship with somebody who is British or has indefinite leave. And if there is a child from that relationship, then it is significantly easier to obtain some kind of leave to remain in the United Kingdom. If there aren't any children, it is more difficult, except where the relationship or the marriage is to somebody who is a European national. For some reason, based on European laws, it is much easier for an overstayer to obtain some kind of legal residence where they are married to or in a relationship with a European national, somebody with, for example, nationality of France, Germany, etc. It's much easier for them to obtain some kind of legal residence based on their marriage or relationship to European nationals. In those circumstances, there is no need for there to be a child from the relationship. Now, Because it's a much easier route, there's no English test, there are no fee, well, there's significantly less fees to pay. It's only £65 for an application based on a relationship with a European national, as opposed to fees in the region of £1,500. So no English test, fees which are significantly cheaper than normal applications, and there is no need to even have a child from the relationship. Because the application does, compared to, well, the applications compared to normal visas is a much easier application to make. And as far as the Home Office is concerned, because potentially there's a lot of sham marriages taking place with European nationals, the downside is that the Home Office will look at the application very, very carefully. Where there's a marriage or there's a relationship with somebody who is British, in my experience, if the paperwork looks right, then the Home Office will generally grant the visa. Contrast that with an application which is based, a European application, which is based on a relationship or a marriage with a European national. In that situation, although potentially, if the paperwork is right, the Home Office will have to grant some kind of leave or some kind of confirmation under the European regulations that you're legal in the UK. They will look at that application much more carefully. There is a risk that the Home Office will want to call both parties in for an interview, really to look at whether this relationship is genuine or whether the relationship, as far as they are concerned, is a marriage of convenience, i.e. a sham marriage. So although relationships and marriages to European nationals do lead to a grant of some kind of residence rights in the UK, the Home Office does look at these applications more closely. A lot more of these applications do get rejected, and it is very likely that an application such as this will result in a requirement that the parties attend an interview with the Home Office, well, where the Home Office can actually test whether the relationship is genuine or not. So that's really the position where there's a marriage to somebody who's British, or a marriage or a relationship, I should say, to somebody who's British or somebody who has a European passport. Let's take another example, something that you come across on a regular basis, where both parties have overstayed. The husband, the wife, they're both overstayers, but they do have children in the United Kingdom. The children might have been born in the UK, or it may be that they were born abroad, but there are children who are living in the United Kingdom. Now, that situation also is one where it's easier for the parents to obtain some kind of leave to remain in the UK based on the children's residence. Again, it's the position of the children in reality which the Home Office actually focus on, and it's through the children in reality that the parents obtain some kind of residence in the United Kingdom. In our previous example, it was the children who were British, and it's based on that the parents obtained some kind of leave in the UK. In the situation where both the husband and wife, they're both overstayers, again you look at the position of the children. How long have the children lived in the UK? And if the children have lived in the UK for a period of 7 years, then the Home Office does need to look at the application more closely, and they need to assess whether it's reasonable to ask that child to leave the UK and go back to their home country, or is it the case that the children should be granted some kind of leave to remain. And if the children are to be granted some kind of leave to remain in the UK, off the back of that, it normally follows that the parents, whether it's mum and dad both or just one, if it could be a single parent, whoever it is who is looking after the children, based on the child's residence in the UK, if it's reached 7 years, it is possible that the Home Office will give the child a visa, and based on that, the Home Office will give the parent or the parents a visa to stay in the United Kingdom. So again, it's the position of the children which assists their parents to obtain some kind of legal residence in the UK. The key factor here really is that the children should have really lived in the UK, resided in the UK for a period of 7 years. Now, I should say, just as a before we move on to the last category, is that the reality is, even where the children haven't lived here, where the children have lived here for 7 years, even then the Home Office does, in many cases, refuse such applications. They contend that it's more reasonable. It's reasonable for the child to leave the country, for the parents to leave the country as well together. Now, if you find that your application is rejected on that basis, then the Home Office will grant a right of appeal. And if a right of appeal is granted, it's in the UK. Parents won't have to leave the UK. There will be a hearing before a judge in the United Kingdom. Now, although the Home Office has refused the application, there's always a good possibility that a judge looking at these factors will grant a visa to the parents based on the child's 7 years residence in the UK. So that's the position of somebody who's been in the UK for a number of years, but the children have been in the UK for 7 years. The final category is those people who have children who were born in the UK and have lived in the UK for 10 years. It is possible for those people to wait for the child to reach the age of 10. As long as the child was born in the UK, has reached the age of 10, the child would then be eligible for nationality in the UK. And off the back of that, potentially you could apply for nationality for the child, and off the back of that, it's possible to apply for some kind of residence in the UK. But the key thing here is this, that if there is a child who's born in the UK, parents have overstayed, the key thing here really is this, that the child has to have resided in the UK before the child becomes eligible for British nationality. Once the child has resided in the UK for 10 years and applies for British nationality or registration and is granted a British nationality, it's at that stage that the parents can apply for a visa or a right to live in the UK based not on their period of overstaying, but based on the fact that they have a child who has now been granted British citizenship. Now, off the back of that, it's then possible for the parents to obtain leave to remain in the United Kingdom. So what I've tried to do on this show is sort of run through the different circumstances and the different circumstances in which overstayers will qualify for some kind of leave to remain, from those who are single to those who are married, those who have married a European national, those who have married a British citizen, those who are here, both husband and wife, they're both here illegally, but they've got children who've lived here for 7 years. Or the last category that we looked at is husband and wife, both in the UK, staying here, living here illegally, but they have children who were born here and they've been living in the UK for 10 years. How in those different circumstances it is possible for somebody who has overstayed to obtain some kind of legal residence in the United Kingdom. So, although it's not straightforward, there are circumstances in which it is possible even for overstayers to regularise their stay in the UK. That, unfortunately, brings us to the end of the show. We'll be back next week on Monday at 6 o'clock. Until then, Assalamu alaikum.